Evening to all. The Tamil Nadu Mediators and Conciliators Association is a non-profit organization formed on 24th July 2015, and the organization was registered in 2016. The primary objective is to promote and exchange of information. Can I continue?
Yes.
The primary objective is to promote and exchange of information on mediation and other ADR methods. How? The organization has been actively involved in promoting mediation awareness through its several activities for the development of the mediation movement. Tamil Nadu Mediators Association is happy to be able to host this online talk show. Is another initiative to understand and learn about the community and court mediation in different countries. I am honored to invite all of you to join us in the initiative in driving a change through technology online talk show. Today, our chief guest, Gunavathi, was admitted to the High Court of Malaya as an advocate and solicitor in 1987. Her main areas of practice encompass civil and commercial litigation, including dispute resolution, SYARIAH management, construction, banking, and family law. She is the pioneer mediator in Malaysia with more than 22 years of experience in alternative disputes resolution methods. She was responsible for drafting the mediation rules, code of conduct, accreditation guidelines, and the Mediation Act for the Malaysian Mediation Center, and deliberated on the Mediation Act with the Attorney General's Office. She is passionate about mediation, and she has brought her energies to bear by promoting mediation as a premier technique for dispute resolution internationally and in Malaysia. She has thus far trained more than 800 mediators, including a broad spectrum of professionals, including judges of the High Court and members of the legal and judicial services, including court mediators. She has also trained judges from Asian countries, lawyers, doctors, quantity surveyors, engineers, architects, accountants, and postgraduate students. For the past 2 decades, she has lectured at the Faculty of Law, University Malaya, the country's premier university for the Master in Laws program in alternative dispute resolution. She has excelled at educating, guiding, and supporting her students in embracing mediation as a primary platform for dispute resolution. She was appointed as an advisor to the Asian Law Students Association inaugural international mediation competition held on October 2020. She has successfully mediated several civil, commercial, and family disputes in Kuala Lumpur, including divorce, child custody, interreligious, insurance, contract, landlord and tenant, employment, and shareholders disputes. She is a much sought after speaker who has delivered papers at national and international conference and webinars. In September 2020, she participated as a panelist and speaker at the international webinar on post-COVID mediation, charting the path of the future, and recently participated as a speaker at the International Virtual Mediation Summer School Program organized by the Supreme Court of India Mediators and the Commonwealth Lawyers Association. She is also an active member of an international mediation organization, Mediators Global Group, and has participated as an expert in providing mediation training to the Swiss Chinese Law Association. Our guest speaker, Madam. Now, I would like to invite Madam, our chief guest, Gunavathi, to deliver her speech, ma'am. Thank you.
Thank you, Kavita and Veena, for that introduction. Namaste to everyone. Very good evening to everyone who is listening in or is tuned in today. If I may just share my screen now. Right. Thank you very much for tuning in. I know it's kind of late for my guest from Malaysia, who has also joined us in this webinar. And to all participants from India, namaste to everyone. Right. So without much ado, I'd like to start the presentation. Now, today's topic is on community and court mediation in Malaysia. Now, community mediation is conducted like any other mediation with the assistance of a neutral third party. So this third party is going to assist the disputants to resolve their disputes. And as we all know, mediation is an informal and flexible method of resolving a dispute. And of course, services conducted and provided by community mediators are free of charge. So it's pro bono. So what is community mediation? So community mediation is defined as a process adopted by a community mediator who is a neutral third party, who is going to assist parties to resolve this dispute. Now, neighborhood conflict is very common, but this does not mean that it has to end up in court. So community mediation may focus on problems faced by the community, such as nuisance in the neighborhood, trespass, family feuds, landlord and tenant issues, neighborhood squabbles involving children, pets, animals, use and maintenance of driveways, party walls, trash disposal, intercultural disputes. So it's very varied. So it is something which parties can look forward to resolve their neighborhood conflicts, especially their neighborhood conflicts, without having to go to the courts. So if these cases were to go to court, of course, it's going to take years to be settled, or time. They're going to spend money. It's going to take time, and there's going to be a winner and a loser. And of course, if it's a neighborhood squabble, it's going to sour your relationship with your neighbor, and you may have to move out from where you're staying and not continue living there in a peaceful way if you're going to continue staying there. So if the matter was going to be settled by the community mediator, of course, the outcome which you're looking at would be a win-win solution for both parties or both neighbors. So community mediation is a flexible process, and parties are brought together in the presence of a community mediator who will then assist to work out their problems with each other, maybe clarify the issues which they have, and discuss their options for settlement and reach a settlement with the assistance of the mediator. Now, of course, community mediation will be done behind closed doors, and it is going to remain private and confidential. And this is why I think community mediation is gaining popularity around the world. And it is not that popular in Malaysia as yet, but I will share with you shortly about the progress of community mediation in Malaysia. So in Malaysia, there are several organizations which have introduced and have practiced community mediation. The first one is called RUKUN TETANGGA, which is a peaceful neighbor program, which was actually started in 1969, actually, a long time ago. And then we have another community mediation center run by the PUTRAJAYA Community Mediation Center. And we also have the STRATA Community Mediation Center. And lastly, the Justices of Peace. So I will take you through this one by one. And let's start with the RUKUN TETANGGA. So the RUKUN TETANGGA was actually set up by the Department of the National Unity and Integrity Department in 1969, as I said. And this was, they introduced community mediation in Malaysia. And the aim of this program was to foster unity and integration among the people, and at the same time, provide an opportunity for residents to resolve disputes at the community level without having to go to court. So this provision actually fortifies the government's efforts in promoting community mediation for resolution of disputes outside the purview of the courts. So community mediators actually started mediating under the RUKUN TETANGGA program in 1975. So there was a peaceful neighbor program which was introduced. And initially when this was introduced, it was introduced to achieve safety and unity among the multiracial citizens in Malaysia. So this is actually a voluntary program that is regulated by the government, and it is created around neighborhoods and neighborhood residents around the country. So it is a neighborhood organization which is made up of particular residential areas. So the power and authority of the RUKUN TETANGGA, or the neighborhood peaceful program, is vested by virtue of the Peaceful Neighborhood Regulation in 1975. Yeah. So initially they were supposed to perform, like you can see from this picture here, they had squad groups under the voluntary patrols scheme in residential areas. So basically it was these residents got together to safeguard the residents living in a particular community, in a particular residential area. So what they did was they got together at night to conduct patrols around the residential area to prevent robberies and petty crimes for safety of the residents. So this is how this pilot program started in 1975. And subsequently, this community mediation center was set up by the RUKUN TETANGGA in 2007 to promote unity and integration among urban citizens. So what was happening is they started training community mediators from committee members of this RUKUN TETANGGA in all these neighborhoods. So currently there are about 1,000 community mediators in their respective residences. So community mediators play a very important role in maintaining peace in the community, as they will be the neutral party striving at helping residents to peacefully resolve disputes or conflicts arising among themselves. So in 2012, the RUKUN TETANGGA Act came into force, and one of the provisions of this act provides that it is the authority of the committee members of the particular community is to provide community mediation for conciliation purposes, and also to settle disputes or difference amongst members of the community. So the committee members of each residential area, they were trained in mediation. They had to undergo formal training, and they were actually considered to be the backbone of carrying out community mediation in all these respective residential areas. And early this year, the government actually launched the RUKUN TETANGGA Community Leadership Empowerment Plan in 2021. So this is like very recent. And they have about 8,274 RUKUN TETANGGA community residents who have, participated in this program. And so these people are the backbone in carrying out unity programs by the government in neighborhoods, although they were initially set up for the purpose of keeping the neighborhoods safe and peaceful. So that is the first introduction of community mediation to people of Malaysia by virtue of the setting up of RUKUN TETANGGA, or Peaceful Neighborhood Committee programs. Next, we also have the PUTRAJAYA Community Mediation Center. Now, the Community Mediation Center was set up in 2015, and of course, the services provided here are also pro bono. It's free of charge. And the mediators attached to this Community Mediation Center are also trained volunteers. So they are all volunteers, so obviously they are not paid. And this center was set up based on cooperation between the government, the municipal council, and a university, which is the University Kebangsaan Malaysia, which is the Malaysian National University, together with the Department of National Unity and Integration. So this was the first, the Department of National Unity and Integration was the first department which actually assisted the government in coming up with the RUKUN TETANGGA program, the Peaceful Neighborhood program. So the aim of the center is to ensure a harmonious and united community by not allowing petty issues to fester. So it contributes to ease tension between the community and encourages the empowerment of the community in making decisions and resolving disputes at the community level. So mediation is conducted to allow the parties to express their dissatisfaction and work out an amicable resolution for themselves so that parties can have a peaceful and conducive environment in their neighborhood. So initially when they started, they did not have a center. So before the setting up of the mediation center, this is a picture of the mediation center in Putrajaya. And before they started setting up the center, the community mediation was actually carried out at restaurants and community halls. So it was very informal, very flexible. It is still informal and flexible now, although the mediations are held at the community center at Putrajaya. And the type of disputes which are mediated are quite varied. So they range from neighborhood squabbles to divorce. So family disputes are included, inheritance, disputes for car and housing loans, bankruptcy matters. So how do you, the types of disputes, maybe I can explain a little bit more about the type of disputes which they have mediated. For example, one of the disputes was tussle for a car park space. So there was dispute between two neighbors, and all because of a car park space. And it was very acrimonious and it was very toxic. So neighbors living around, these two neighbors were living in a very uncomfortable situation. And the Putrajaya Mediation Community Center actually resolved the dispute. And another example which I can give you is a quarrel between a committee member of a religious institution and the parents of a child who was hit by the committee member for playing football near a place of worship. So in the end, this was also resolved at the Community Mediation Center by a compromise, and both parties agreed to forgive and forget about the dispute. Okay, and the other type of dispute which the center has also resolved is a family dispute where single parents are struggling with financial constraints. So the type of disputes mediated at the community mediation center at Putrajaya is also very varied. And as at 2019, the center has handled about 310 cases and resolved about 215 cases. So it's a very high success rate of about 70%. Since it is establishment, so they have a good success rate, and hopefully they are able to take in more cases at the center. Now moving on, the next is the STRATA Community Mediation Center. Now, the STRATA Community Mediation Center is a collaboration between the Commissioner of Buildings, the Department of National Integrity, and the Putrajaya Mediation Center. So this STRATA Community Mediation Center was set up in 2018. So as you can see, this is a picture of a high-rise building. There are many high-rise buildings in Malaysia. And there are lots of complaints about a lot of disputes going on by residents living in this strata community. And in Malaysia, we have the Strata Management Act 2013. So the Strata Management Act basically is an act designed to provide for the proper maintenance and management of buildings and common property and other related matters for people living in strata or stratified buildings. So besides some of the problems which arise for people living in stratified properties actually are outside the ambit of the Strata Management Act. So for the Strata Management Act basically deals with problems like maintenance, payment of sinking fund, things like not maintaining the landscape in the common property, rainwater downpipes in the community, which has to be looked after by the building management, etc. But outside the Strata Management Act, there are also other types of disputes which normally arise between people living in stratified properties. So this center, the aim of this center was basically to deal with these type of complaints outside the purview of the Strata Management Act. So what happens is if you have a complaint or dispute which parties wish to air, so the parties will visit the mediation center and to air their grouses, of course, and sometimes they may come together and sometimes they may come separately. So if they come separately, the mediator at the mediation center will then contact the other party to fix a date, to come forward to hear the other party's side of the story as well. So these services are provided free, and currently in Malaysia, it is housed at the town hall in Kuala Lumpur. And this is part of the service which they offer for free to residents living in stratified properties. So what are some of the types of disputes which may occur between neighbors in stratified properties? It's actually quite a few. So one of which is noise. And noise is terrible, as you can see from this picture. So, you know, because you're living in a stratified property and the walls may not be too thick, and if somebody plays the guitar or music loudly, the neighbor may be offended, or they may play loud music, or you may have people stamping their feet from someone who's living upstairs, and the neighbor downstairs may not be too happy about the noise, right? And there are lots of problems in stratified properties, and one of which is noise. And the other issue could be smell or parking issues, which neighbors may get into a squabble, rubbish disposal, dumping rubbish into the neighbor's unit, outside the neighbor's unit, boundary issues. So there are a lot of aggrieved parties living in stratified properties in apartments or condominiums. So the daily reports show that the statistics that approximately 4,000 complaints are lodged by Kuala Lumpur residents, were actually lodged by Kuala Lumpur residents between 2012 and 2017. And these complaints are via letters, emails, phone calls, and sometimes it's face-to-face. So this center actually deals with these kind of disputes. So it can be very acrimonious disputes, and it may sound very petty, but of course it's not difficult to, it is difficult to deal with these kind of disputes, especially if people are living next to each other every day and, you know, having to put up with all these things. So the community center is actually an excellent way of dealing with these disputes, because I mean, I don't think you want to take your neighbor to court for, you know, a noise, for being noisy, because it just doesn't make sense, because the amount of money you're going to spend in filing a suit, etc. This just doesn't make sense. So this makes sense, community mediation center, to resolve these kind of disputes. So moving on, the last type of community mediation center which has come about in Malaysia is called the Justices of Peace. Now, the Justices of Peace are actually a heritage of British rule in Malaysia. Initially, when the British were here, district officers and assistant district officers were appointed as Justices of Peace to alleviate the inadequate pool of magistrates at that time during the British rule in Malaysia. And this went on for some time, and it is still carried forward till today. And at present, the Justices of Peace are appointed by the respective state authorities and are conferred powers not exceeding the powers of a second-class magistrate. So the Justices of Peace in the state of Penang, one of the states in Malaysia, actively promoted neighborhood mediation in 2017. And until today, they have a separate mediation bureau set up in the state of Penang. And the Council of the Justices of the Peace Penang set up the Mediation Bureau to advance the use of mediation in the state of Penang. So this was to cater for community mediation in resolving conflicts arising within the small and medium business community. And this includes, so later on, they expanded the type of disputes to community and family disputes. And the mediators at the Justices of Peace Mediation Bureau in Penang have also undergone mediation skills training, and they are all equipped to mediate a variety of disputes, including community mediation and family disputes. So it is envisaged that the trained Justices of Peace in Penang will act as community mediators on a pro bono basis for, you know, for now and in years to come, to allow members of the public to have easy and affordable access to justice for their disputes, and at the same time to help alleviate the strain on the court system in not having an avalanche of civil cases for community disputes, which just doesn't make sense. So this is what community mediation is in Malaysia for now, and hopefully that this will, expand in other states as well. So performing the duties of a community mediator is not an easy feat, because it is somewhat challenging, I would say, because you need a certain measure of skill, you need the ability and valor to succeed. So this is because when you're dealing with human conflict, especially, you may think that a neighborhood squabble is easy to resolve, but I don't think so, because human conflict is complicated and involves a lot of emotional upheaval. So some of the greatest challenges, I would say, of being a community mediator in Malaysia is recognition and acceptance by the disputants. The level of awareness, recognition, acceptance, and trust from the disputants is very important to determine the level of cooperation from the parties, as well as their willingness to openly and rationally discuss their issues, which will ultimately influence the outcome of the mediation. So that is community mediation in Malaysia for now. It's not really, I wouldn't say that it's widely spread. It's just barely starting, actually. And I sincerely hope that, it will spread to all the other states as well. So hopefully community mediation centers will be set up all over the country as well to deal with these kind of disputes. The other topic for today is court-based mediation. And in Malaysia, there are two different courts. One is the Sharia courts for the Muslims. They deal with family disputes for the Muslim community. And you have the civil courts. So the Sharia courts were actually the pioneers who started court-annexed mediation in the year 2002. And the Court Mediation Center in Malaysia was started by the state of Selangor. And they are the pioneers, as I said. And the process is called suluh. And this suluh is actually meaning the end of a dispute. That's what it means. So the practice of suluh was accepted as an integral part of the Sharia court system in the state of Selangor, and then it was codified. Now this has spread to all the different states in Malaysia. So each state has its own codified enactment to codify mediation in the Sharia courts. And the process is the facilitative mediation process model. So what happens at, this is a typical photograph of a mediation in the court, in the Sharia courts. And as I said, they deal with divorce, custody, maintenance, and inheritance of Muslims in the country. So if there's a dispute involving any one of these categories, they are referred to suluh first. So suluh proceedings in the Sharia courts are handled by officers. They are called suluh officers, but somehow, I do not know for what reason, lawyers are not allowed to attend these proceedings. So the lawyers are left out for the mediation process at the Sharia courts. And the Sharia courts, as I said, only have jurisdiction over matters concerning Muslim family law. And so the proceedings are held similar to a normal mediation process, which is facilitative with the aid of the mediator. It is also confidential. Parties sign a confidentiality agreement before commencing the mediation process. So that is how it's done for the Muslims in the Sharia courts for family disputes. Now moving on to the civil courts, this is a picture of our courts in Malaysia, and we've got a beautiful building. So the court annexed mediation program was introduced in the year 2010. And this was by way, it was not part of the rules, but it was introduced by the Chief Justice by way of a practice direction in 2010. And the initial motivation of setting up court annexed mediation in the country was, I suppose, like in any other country, was to clear the backlog of cases in the courts. And the practice direction governs civil and commercial cases. So all judges of the High Court and the subordinate courts at the pre-trial case management stage were given directions, or are able to give directions, to refer the dispute to mediation. And in 2011, there was more progress after the practice direction was issued. The Kuala Lumpur Court Mediation Center was set up. So the Kuala Lumpur Court Mediation Center is housed in this building. In this picture, as you can see, it is part of, it is housed in this building. And we have a beautiful center, actually, the Kuala Lumpur Court Mediation Center. There was a pilot program which was set up offering free mediation services. So currently in Malaysia, court mediation centers have been set up around the country in all the different states in Malaysia, and parties can opt to go for mediation once they have filed all their papers in court. So the main provision is for parties to file a suit in the courts before they can use these services. So the Court Mediation Center is manned by permanent administrators and court officers in charge of the administration and operation of the mediation center. Now they have their own private mediation rooms. They have nice mediation rooms. They have caucus rooms. They have lounge facilities, and these facilities are provided for counsel and also for the parties. So in the types of dispute which are handled by the Court Mediation Center, which is encouraged by the Chief Justice, was issued by way of a practice direction. And these include personal injury disputes, damages for road accidents, monetary claims, defamation suits, commercial suits, contractual claims, matrimonial disputes, and intellectual property disputes. So it's very varied, and these are the types of disputes recommended for mediation by the Chief Justice by the issuance of the practice direction. And the court mediators are High Court judges. They could be also mediators from the mediation center, private mediators, because the practice direction actually allows for mediation in the courts to be referred to private mediators outside. And private mediators could be from the Malaysian Mediation Center. They could be from the AIAC, which is the Arbitration Center in Malaysia, and mediators from SIDRAC, which is mediators for the Dispute Resolution Center for the shares, for share disputes, and those kind of disputes which involve investment disputes. So it's very varied. But if you go to the center, then of course the mediators will come from the center itself. And all cases at the center, as I said, must be filed in court before they can be referred to mediation. So the registrar or the judge will then allocate the cases for mediation if it's suitable for mediation. And if the High Court judges feel that they want to mediate the disputes themselves, then the judges may opt to conduct the mediation in their chambers. But if they are not comfortable, then it's referred to the mediation center for it to be mediated at the mediation center. So the full-time mediators usually mediate cases from the lower courts, and the High Court judges normally mediate cases registered with the High Court. So the records of the cases which are mediated are usually kept at the mediation center because it's confidential. If the cases are not successfully mediated, then the matter will be sent back to the respective High Court judges for trial. And the notes taken by the mediators at the mediation center will not be shared with the High Court judges for confidentiality purposes. So the notes of the mediator will not be sent to the trial judges if the matter is reverted back to the judge for hearing. So another provision which I would like to highlight is if the High Court judges opt to do mediation, they cannot be the trial judge as well. So what happens is if they mediate a dispute and mediation is unsuccessful, then the case will be sent to a different judge for trial purposes. Because of confidentiality reasons, it cannot be heard, the trial cannot be conducted by the same judge. So this is how it works. And of course, if it's conducted by the judges and at the mediation center, the mediation is free of charge. It's pro bono again. But if it's referred to mediators at AIAC or MMC, which is the mediation centers outside the realm of the courts, then of course parties would have to pay. So that's why people rather opt to have their mediation done at the center, at the court center, because it's free of charge. And that could be one of the reasons why the statistics of mediation being conducted at other centers outside the courts are not very high. So they don't have many cases because court mediation is free as opposed to mediation at the centers where parties would have to pay for the services of the mediators. Now, before I end, I would like to share with you what are the advantages and disadvantages of court mediation. Now, of course, the advantages of court mediation is around the world. I think court mediation, court annex mediation has actually grown to clear the backlog of cases, as I said. And also because of a result of the undesirable conditions in many legal systems around the world. So court-based mediation has actually succeeded in dealing with these problems, systematic problems in many jurisdictions. So confidentiality and party autonomy remain the key feature in all these mediations. So if the matter does not settle, of course, the judicial mediator is prohibited from presiding as the trial judge, as I said. And because confidentiality is one of the hallmarks of mediation, it doesn't operate like an adversarial system, a court-based mediation. Parties need to sign an undertaking of confidentiality before the commencement of the mediation process. So in Malaysia, what happens is before you go for mediation, parties would need to fill up or sign this undertaking of confidentiality that they will not reveal anything said and done during the mediation proceedings should the case go to trial subsequently if mediation fails. So the disputing parties in mediation in Malaysia can attend mediation with their lawyers, unlike the Sharia courts. So lawyers are permitted to attend the mediation sessions, but unfortunately, most of the times the lawyers attend the mediation session for a very short while, and then they're sent out to wait while the judges or the mediators who are mediating in the court, officials who are mediating in the courts, only mediate in the presence of the disputants or the parties. So half the time the lawyers are waiting outside, and when they are called back together, sometimes the matter has already been settled. I mean, this is not the way normally mediation is practiced, as we all know. So I do not know why they use this method. Of course, I have personally trained many mediators from the court officials, and I have posed this question to them. Now they have come back to me to say that they feel that sometimes lawyers are the stumbling block, when it comes to settling matters. So they feel that it's safer to just hear from the lawyers at the beginning about what the case is about, and when it comes to the actual negotiation of the case, they would rather not have the lawyers there, and that is why they send the lawyers out, and the proceedings are continued without the presence of the lawyers in the mediations room. So this is something which is practiced in Malaysia. I don't know whether this is practiced in India. So maybe you can share with me later how mediation is conducted in India. And the judicial mediator may also have private sessions or caucus sessions with each of the parties, and this is not prohibited. Like in some jurisdictions, caucus sessions are not allowed during court mediation. So some of the advantages, let me just move on to the advantages of court mediation. Now, the timing of mediation can be controlled and supervised by the judge or the court officials conducting mediation. So this is very timely because they do set a timeline. They do give timelines, even if there's continued mediation, parties are given a strict timeline to comply so that no time is wasted in dealing with these disputes. And secondly is, of course, it reduces the caseload of the judges. And that is one of the main reasons why court mediation was started in the first place. And the other advantage is, of course, disputants get to participate in the process. It is not adversarial in nature, and therefore parties can be personally involved in their resolution of their own disputes, because, as we all know, mediation is a party-empowered process, and parties can resolve their own dispute by having open communications with the other party, and they get to participate and have their day in mediation, as I would say, not their day in court, but their day in mediation. So this is all done in a very conciliatory manner, and so parties are expected to make candid disclosures to the judicial mediator, who may then assist the parties to reach a dispute. And the same lawyers can also, in the event it is not successful, the same lawyers can also represent their clients at the trial. So this also saves time, and of course it is quick. There's a quick resolution, and it's harmonious with the court's guidance. And one of the other advantages, which is commonly cited, is that judges actually bring their moral authority to the mediation process. So when parties come for mediation before a judge, as opposed to a private mediator, because the judges have that, they wear that cloak of authority, parties tend to resolve their dispute more readily, I would say, as opposed to if the mediation is conducted by a private mediator. And so the judges are seen as, agents of peace for the parties. So these are some of the advantages. And lastly, some of the disadvantages of court mediation is, I think one of the main disadvantages of having a judge mediating a dispute is the question of the suitability of the judge in taking on such a role. Because there, of course, there are many people who oppose judicial-led mediation, because they say that judges are not meant to mediate. Judges are meant to judge, so they should just stick to their role. Of course, there are proponents and opponents of this proposition. And not all judges are suited. In my view, of course, not all judges are suited. I have conducted a lot of mediation workshops for judges, to train judges. And many judges actually have this to say. They say that it's easier to be a judge than to be a mediator. After having undergone the training, the mediation training, judges actually say that they rather be a judge than to be a mediator, because it's definitely more difficult to be a mediator, because you need a different set of skills to be a mediator, especially if you're a judge. Because you're so used to judging, it may be difficult for you to wear a different hat when you're mediating, because you need different sets of skill sets are totally different. So that is one of the main disadvantages of judicial-led mediation. And the other risk is, of course, parties may feel uncomfortable and fear that the judge mediator may not be able to receive information and keep it confidential. And this fear is especially if the same judge is going to be the trial judge. Of course, as I said earlier, preferably it should not be the same judge. But if you are in a state, like some of the states in Malaysia, not very, they do not have many judges. And what if that particular state only has one judge? And if the judge is going to conduct the mediation, and if mediation fails, he has to hear the matter as well, and the trial has to be before the judge. So that fear of the judge being, the one who's going to hear the dispute later on may make parties feel uncomfortable, because the judge is, after all, part of the court system. So this is another one of the disadvantages. And they feel that they may be prejudiced. Parties may feel that they will be prejudiced, and they may not trust the system itself. So this is especially so if the judge is going to meet parties in a private session. So there might be a reluctance on the part of the parties during the mediation session to share their concerns openly, to share what their interests are openly. So this is not one of the plus factors for court mediation. And lastly, parties may feel pressured to settle, because they feel because the judges are there, and they may feel that it's a pressure for them to settle the matter. So just want to share some statistics with you. Some of the statistics in Malaysia is the court annex mediation program over the years has a high success rate. And in 2018, there were about 10,391 cases at the Sessions and Magistrates Court. And the Sessions and Magistrate Courts are the subordinate courts in Malaysia. And in 2019, there were about 545 cases registered in the High Court. And out of that 545 cases, 242 were successfully mediated. And in 2019, there were about 2,545 cases at the Sessions Court, and about 1,437 were successful. And lastly, in the Magistrates Court, there were about 232 2,337 cases, out of which 1,532 was successful. So the success rate of cases at the court mediation center is actually pretty good. And lastly, I would like to conclude that the judicial mediator, of course, operates with certain strictures peculiar to facilitative mediation. And he, of course, it's going to be difficult for him as a judge because he cannot give any legal advice or express any legal opinion during the mediation process. So although the judicial mediator's role is not adjudicatory in nature, the judge's stature actually lends the mediation process a seriousness that facilitates settlement. And of course, the skills of a trained mediator is completely different from a judge. So mediating requires the judge not only to wear a completely different hat, but to also have a completely different mindset. So there needs to be a paradigm mindset shift actually. So of course, it's not easy for a judge to mediate because his job is actually to judge, not to mediate. So he needs to learn these skills, and of course, they have to undergo training to achieve this, and it's not easy because it's a totally different skill sets which they require, and it's not easy, but I'm sure with the proper training and guidance from the trainers, judges can be mediators as well, because mediation is an art and a skill which actually can be nurtured. And with proper mediation training and a paradigm mindset shift, I think judges too can become skilled mediators. Thank you for listening.
Gunavathi, it was a very interesting presentation.
Thank you.
Very informative and interesting. I have a question. Has mediation effectively been used in collective disputes in Malaysia? Disputes concerning a number of people, such as, say, an environmental dispute or a labor dispute where members of a trade union have been affected. Has mediation been used in such cases as well?
Okay. Thank you, Priya. It's a very good question. Actually, it has been used, especially in East Malaysia, where they have native courts disputes, because in Malaysia, you must understand, it's a multicultural society, and we have the indigenous people living in mostly in the East Malaysia, in Sabah and Sarawak. They're known as the East Malaysian states. So there have been cases where the natives or the indigenous tribes have actually experienced a lot of land issues with the government, and they have actually collectively referred these disputes to mediation to the native courts. But recently there have been a couple of cases which have been referred to mediation, and this involves the whole village, as I would say, because the natives live in a community. And I believe I've been informed that I have not been personally informed, but they have consulted me in respect of some of these disputes which involving these natives, and it's actually ongoing. And the other dispute which you talked about, employment disputes, trade union disputes. See, the industrial court in Malaysia also practices, they deal with employment disputes in Malaysia. And they have also practiced mediation. They have trained mediators in the industrial courts in Malaysia. So they also do conduct mediation at their courts for employment disputes. Does that answer your question, Priya?
Yes, thank you. And I would be interested in knowing more about your work on the case concerning the indigenous communities. So maybe if you write something on that, you could share it with all of us.
Yes, I will. Definitely, I will. But currently, it is all referred to the courts mostly. But it is very difficult to actually mediate collective disputes, as I would put it, because you're dealing with a big group of people. And normally in mediation, it is only 2 or 3 people involved in the mediation. So if it's a collective mediation, it is a bit difficult because different people have different views. Because when you come for mediation, one of the primary concerns of the mediator is whether the party attending the mediation on behalf, let's say on behalf of a company, has authority to settle. So what more if it's a collective dispute and you're dealing with a large number of people like the natives, and they all come from a particular village, and they have most probably would have authorized the community leader in that particular village to represent them. But of course, not the whole village may be agreeable to appoint that person. There may be other people who may want to have their say. So this is one of the main difficulties faced by mediators in collective mediation. So of course, Priya, I will share with you if I'm going to write a paper on this topic. I will share this with Kavita.
Thank you very much.
Yes, thank you, Priya. Any other questions?
Good evening, ma'am. Good evening, ma'am. Me, I'm Dana Lakshmi. Thank you so much, ma'am. It is very useful and I really learned a lot. One more, just I wanted to clarify. You were telling about the STRATA Community and Management Act, which is
Yes.
really particularly about the management of the building and the structure, which is with the water maintenance. Is that so? As community mediation is, they can entertain any other causes or cases, nature of cases.
Okay. So you're talking about the Strata Community Mediation
Yeah,
Center.
exactly.
Right. Okay. See, in Malaysia, we have the Strata Management Act. Okay. So the Strata Management Act is applicable for stratified buildings in the country. So it actually covers a wide range of topics, which includes maintenance charges, because for stratified properties, if you're living in a condominium or an apartment, you need to pay maintenance fund for maintenance of the common property in the building, like let's say the swimming pool area or the corridor or the landscape, etc. And they also have sinking fund where you pay for painting the walls, etc. Right? So these are some of the examples. But besides these kind of disputes, which are governed by the Strata Management Act, there are other disputes which don't come or fall within the purview of the Strata Management Act. Now, these could be neighborhood squabbles, as I said, like noise. Let's say your neighbor is a noisy neighbor. So that doesn't fall under the act. So those kind of disputes can be referred to the Strata Management Community Center.
Okay. Oh, okay. Kind of you. Thank you. Yeah, yes. Yeah, I thought community center, which includes other neighborhood problems or personal laws, also involves, I thought.
Yes,
okay.
That's right.
Okay, thank you.
Do you all have such a law there in India?
No, we actually we don't have high-rise buildings at all. Our corporation never entertained at the earlier. Now only they are allowing each at least 90 to 20 stories building only. Earlier we don't have, and we don't have like Strata Community Management Act such. Madam Padma is also there to clarify. I think she's
amazing.
Thank you.
I'm
Thank you, ma'am.
Regarding the apartment, because in Malaya you have the high-rise building, so that's why maximum 75 floors, maximum like that only. But in India we don't have that height. But even now we are raising our floors. But for that we have a very good consumer forum. There you can raise your problems, and there you can settle the issues regarding the maintenance, regarding the buildings.
I see.
How to set right with your builder. And even now we have a RERA Act, Real Estate Authority Act we have. So the dispute between the builder and the customer, if the problem, they have a separate act. For that we are dealing with the cases with the separate court. That is what the RERA court we have.
I see. And for training in Malaysia, for training in Malaysia, we have we do not have a national regulatory body to regulate mediators in the country. So training is normally conducted by different organizations like the AIAC. They conduct their own training and they have their own panel of mediators. The Malaysian Mediation Center, which is under the auspices of the Bar Council, they conduct their own training centers, sessions, and they have their own panel of mediators as well. So you have different organizations having their own panel of mediators, but training can be done, can be outsourced to people from other countries. Or initially when they started training, we were trained, like I was trained by people from Australia, trainers from Australia. And sometimes they also use Singapore trainers. And I have my own training sessions as well. And I have my own workshops. I've conducted workshops for judges, for lawyers, and many people. I've trained about 800 mediators. And so different organizations have different training, but generally the requirements are for a 40-hour mediation training session and with an assessment. So it's normally run over 5 days with assessment at the end of the day. And on the 5th day, you have to sit for this assessment. And upon completion of that assessment successfully, you can be accredited as a mediator.
It's a training program. So
Okay.
you just said that training is given by outside, training is outsourced, and then they are accredited mediators.
Correct.
So the people who get trained and are those accredited mediators are attached to court. I mean, will they be accepted by the court for mediation when it is a court-annexed mediation?
Okay, good question. Because in Malaysia, the court mediators do not accept outside mediators as on the panel. So all the mediators who are based in court are all government officials who are picked from the government service. So private mediators like me, we cannot apply to be court mediators. So it's a two different systems. Yes.
Okay.
Okay.
And another question I had about this community mediation. Generally, it is 2 mediators who will be doing, or it is just 1 mediator for community mediation?
Normally, it's 1 mediator. So co-mediation is not very common here because normally, if in private mediation, co-mediation is possible, but they end up paying fees for 2 mediators. But for community mediation, it's normally 1 mediator because it's also free. Remember, it's pro bono.
Okay. Yeah.
Madam, what is the procedure that being followed for international mediation? And also, is there any possibilities of conducting mediations in your country or in our country by the abroad mediators?
Sorry?
Will it be acceptable?
I mean, if you want to come and mediate in Malaysia, is it?
Just I'm asking for the namesake. Is there any permissibility to conduct mediation from outside the country?
Yes, I mean, if it's online mediation, you can conduct from wherever you are. There have been cases where we have mediated on an online basis for disputes involving other residents. So let's say you have a dispute with someone in Malaysia and you are in a mediator in India. in Chennai. So the dispute is between a resident in Chennai and someone here. You can conduct online mediation. That's possible.
Is there any possibility of the physical appearance to conduct mediation by the advocates who have? Is there any possibilities?
Yes.
The advocates from India to conduct mediation in Malaysia?
Conduct mediation here.
Yes.
You see, the thing is, if you want to conduct mediation here, you have to be part of an organization. So currently, mediation conducted in Malaysia is by all these various organizations, one of which is the Malaysian Mediation Center. The other is the Asian Arbitration Center. And these are all the international organizations. So if you get accredited to the centers, then you can be part of, I'm paneled on the panel of these mediation centers. You can apply to be on the panel.
Okay.
So, but you need to qualify, you need to be able to comply with their requirements. So each organization will have their own requirements.
What
Like
is the basic requirements?
AIAC is an international arbitration center. So they have their own mediation center, and they have international mediators. They do have.
Is there any specific course for conducting international mediation?
Specific course, no, it's the same course, but it is the course which you have undergone which will determine whether you are recognized as a mediator by the respective organizations.
Yes.
Okay.
Okay. Thank you, madam. Thank you.
Welcome.
May I ask a question, Madam Gunavathi? A hybrid dispute resolution, take instance arbitration come mediation, which is also known as RMAT.
RMAT or MAT.
So what is your viewpoint, Madam? Thank you.
Right. Okay, RMAT or MAT. Now this is very tricky. Of course, in Malaysia, the arbitration center or AIAC, they have RMAT, MAT rules in their mediation and conciliation rules. So my view is, I would say that I am not keen on RMAT or MAT because my view is that it is difficult to wear one hat and then switch to the next hat. And if it's MAT, if you start with mediation first, if I were one of the parties and, you know, I realized that I'm going to go for mediation, and if it's not successful, it's going to be converted to an arbitration proceeding, I may not bear it all with the mediator because I may be a bit cautious in giving or revealing certain information to the mediator because I would be afraid that if that might be used against me. Of course, there's a lot of literature on this, on RMAT, MAT, but it seems to be a very popular way of resolving disputes now. One of the reasons is because mediation doesn't have, if you do not have enforcement proceedings or rules in your country, which you do have in India because you have your Mediation and your Arbitration and Conciliation Act, which actually gives it the force of law to enforce mediated settlement agreements, which we don't have in Malaysia because our Mediation Act is silent on enforcement. So it is just a contract. So why people opt for MAT-ARB is because if it's converted to an arbitration proceeding, it has better enforcement rights because the arbitrator will then hand down an award at the end of the day, and you can then enforce that award. But if it's a mediated settlement agreement, it doesn't have that force of law. So we are actually in the process of trying to amend our Mediation Act so that we can also ratify the Singapore Convention, because otherwise it's going to be difficult to ratify the Singapore Convention.
Thank
Does
you,
that
Madam.
answer your question?
Yes, Madam. I understand that the mediation Act is silent on the enforcement rights. If
Yeah.
the Mediation Act has been drafted more clearly, then would you agree that the ARP-MAC purposes will be taken less in the future? Or is it, or is the hybrid solution, I apologize, or does the hybrid dispute resolution is just a rule for now, which is ad hoc for the purpose of saving the interest of an organization?
I don't know what the purpose is, but of course, for enforcement purposes, it is of course a good method of resolving a dispute. Yeah, so I am not too sure about that.
All right, thank you, Madam.
Okay. Kavita?
I think we are just at the end of our session. Thank you, Madam. It's been a long day for you. Thanks for holding for us. Thank you. It was a pleasure having you and listening to you. Thank you.
Thank you. Thank you. Thank you, everyone. Good night.
Thank you.
Good night.
So now may I conclude this session. Really, it is very wonderful, Madam Gunavathi. The session on about community mediation has given an in-depth and insights about the mediation. And regarding your mediation setup, you have given 4 types of the mediations, that is PUTRAJAYA and PUTRAJAYA Community Center and STRATA Community Mediation Center and Justice of Peace. Very elaborately, you have discussed each and every step of the mediations, and you have given a very good statistical data regarding the mediators also. But I would like to expect how you are selecting the mediators. That's what I am expecting, that more than 1,000 mediators are in your group. So based on that mediators, various types of the mediators, like that you have said, judges, center media, private mediators, and mediators from AIAC and MMC and SIDREC, like that only you have stated. So you have the what type of cases and who are the mediators, like that only you have a strategy of the mediators, very elaborately you have discussed. So it is really very nice and very good insight on the community mediation in Malaya. We have a video, live video, we have seen the presentation in the VC, that is in this video conference. Really, I am very grateful to you, Gunavathi. Your presentation, the live data we got it because we won't forget the live data of the Malaya mediation centers and how you people are settling the issues. Very successful rate, nearly 70% of the success rate in the mediation centers. You have given a very good presentation, and your data is also very thoughtful to how to improve our mediation success rate. Really, it is giving very immense pleasure to know all about it. Thank you so much for your presentation.
My pleasure. Thank you very much for inviting me. And I must thank Kavita for organizing this and inviting me for this session. I enjoyed this presenting this for you, and hope to see you all in the future. Thank you.